A significant step for the Justice Department and its investigation into the January 6 attack. Sources tell CNN the DOJ is trying to force the testimony of Pat Cipollone and Patrick Philbin, the top two lawyers from Donald Trump's White House, and hear about their conversations with the former president. This is exclusive new reporting. So let's get right to CNN's Sarah Murray. Sarah, this is an attempt to break through a firewall of sorts that Trump has used to avoid scrutiny of his own actions.
That's right. The former president has cited executive privilege, attorney-client privilege in trying to bar a lot of these top witnesses from sharing with criminal investigators looking to the events surrounding January 6th from getting too close to conversations folks may have had with the former president, those in his inner circle. So what we're seeing with this effort by the Justice Department to compel Pat Cipollone and Pat Philbin to testify again is to try to get closer to the former president and that inner circle. So that's a court battle that's playing out in secret. It's a sealed proceeding. We have seen the Justice Department have some success in piercing this sort of privilege shield with other witnesses, though. Sources have also told me and my colleagues, Evan Perez and Caitlin Polantz, that two top aides to former Vice President Mike Pence, Mark Short and Greg Jacob, have already gone in and testified again before a grand jury. They were facing these sort of similar privilege fights, and a judge ruled that they had to go back and they had to answer more questions. So this is really important for the Justice Department's investigation into January 6th. We, of course, reached out to a Trump spokesperson for comment. He slammed the weaponized Justice Department and called all the investigations surrounding the former president witch hunts.
Sarah Murray, thank you so much for this brand new reporting. I want to bring in Elliot Williams, a CNN legal analyst and former federal prosecutor. Elliot, what does it take to pierce a privilege like this, whether it be executive or attorney-client privilege? What would it take for a federal judge to rule that they have to testify?
Yeah, look, and you're exactly right with that question, John, because any former president is going to be entitled to some measure of protection for conversations that happen in the White House with attorneys, either via attorney-client privilege or executive privilege. Now, look, as this has come up over the years, going back to Richard Nixon, it's very hard for a White House to overcome the criminal process. And if criminal investigators are looking into something and believe that there might be evidence of a crime somewhere, then certainly they can pierce those privileges, and that may happen here.
Evidence of a possible crime. What then do you think it is that the Justice Department, that investigators want to get at? What door could be opened with the testimony of Philbin and Cipollone?
Now, look, if it's related to January 6th, my assumption is that it might be tied to the false elector scheme that we've heard much about, which is possible communications with the White House and individuals around the country as they were seeking, and as folks were seeking to undermine the results of the 2020 election. That's a guess here, but we just don't know because, as Sarah's reporting had noted, this is happening in secret. These are sealed proceedings because of the sensitivity of them. But look, any number of matters would have come through the White House, and certainly you and I are both well aware of the number of investigations surrounding the former president. So at this point, who knows?
Cipollone did speak to the January 6th committee, although it was in specific areas with parameters. Presumably there wouldn't be the same parameters here. And I just want to make this understandable for our audience who, like me, we don't have law degrees. The issue here is what? If prosecutors can prove to the judge, if they can make the judge determine that Pat Philbin is a witness to possible crimes, I guess the standard would be more likely than not that crimes were committed. If he was a witness to such crimes, then that testimony could be compelled?
Yes, it certainly could be compelled. Now, look, any advice he's providing to the former president in his capacity as a lawyer is going to be protected. But there's a world of materials that might have happened outside of that scope. If he's not advising on the law and merely is seeing crimes happening, is a party to a crime himself. Now, we don't have evidence that that's happening. If he's, if he's aware of someone else's knowledge of crimes, all of those are fair game. All of these privileges, like attorney-client privilege or executive privilege, seek to protect are the specific communications themselves in the context of the person's job. But that's not going to protect lawbreaking, if in fact that did happen.
And the fact that Mark Short, who was chief of staff to Vice President Mike Pence, and Greg Jacob, who was himself a lawyer, the fact that they have already testified and through whatever legal process were either compelled to or voluntarily did, the fact that they did, is that a precedent that will play here?
Oh, absolutely. Mark Short and Patrick Philbin, who was a senior attorney in the White House as well. Frankly, that and again, I made a reference to Nixon before and the efforts that were used to pierce some of these attorney-client privilege questions. But no, the mere fact that the nation has seen testimony from senior White House staffers and senior lawyers will absolutely be in the mind of the court that is considering whether it is appropriate to break or pierce, to use the term, these privileges that exist.
All right, Elliot Williams, thank you so much for helping us understand this. We will watch this resolve itself perhaps quickly. Thank you so much.